and everybody calls it a coupon. It's got perforated top on it. Now think about a check. If you're writing a check, pay to the order of, you got a box over here to fill in, and then don't you have a routing number and stuff across the bottom of the check? They just forgot to put the line down here so you can sign it.
Oh, okay, got you.
So once the title of this is not in Mr. Cooper's name, you're not the investor anymore. You can retitle it into your trust name. And then every month when you get this bill, you can be the president, sign it, stamp it, and deposit it in your trust account. And the dollar amount that's up here will credit the account.
So you're getting money every time you get this coupon in the mail.
Yeah.
This is a coupon.
This is the bond up top. That's the check.
People say that's an electric bill, right?
Right.
But when you're at a restaurant, what do you ask them for?
The bill.
The check. Check, please.
Oh, the check.
Yeah.
So the bill is a check.
Yeah.
It makes sense.
You just gotta learn how to sign it and deposit it.
Gotcha.
Only a president can approve bills, correct?
Right.
So you're a president of a corporation.
So I can...
Hey, that's lit.
And see, then whenever you start getting mail, it'll show Jason Wade May, irrevocable
Look, he got his trust.
Jason Wade May, trustee.
That's lit. That's tight. He's got him as a trustee right on the bill.
Interest and dividends earned, shares.
So it switches everything up.
Yep. Dividend checking. This isn't the same as a regular checking account. It's a trust account.
Trust account, yeah.
Yep. And this is just a local employee credit union. They don't even do business accounts. But I got a trust account here.
Right.
So it's a private account.
Gotcha.
This is the...
There you go. This is talking about restricted deposit services. You have to find what your QSIP number is related to the birth certificate or whichever security. If you're going to do your birth certificate, that's going to be the certificated security. If you're going to do your social, that's an uncertificated security, according to UCC 8-112. Look at the list here. We got 24. The first one, stock or bond. Number 2, corp resolution. But let's go down to number 7. 007 for your eyes only, otherwise known as the Order of Tubal Cain. And it is birth certificate or a death certificate. So when you find your fiduciary to go into your account, they're going to go into the section of 007, plug in your birth certificate number, most likely the one that is authenticated, and that is going to spit out a QSIP number at the top. Excuse me. That QSIP number has to be given to the judge when you go into what's called insolvency court, bankruptcy, and if there's any money there for you or your trust, it's going to be deposited in the name of the trust, not directly to you. So I thought that was very interesting how, yet they can put out this information, but on the other side, within the actual holder of these accounts, they actually provide validity. Very interesting.
So I want to just make you guys think for a second. Y'all listen to something. So this says, this article is a discussion of the public securities and obligations. That is the obligations consisting of various types of paper issued by the United States, various states of the Union, and various political subdivisions. Can you guys think of a bond, coupon, bill, notice, certificate, warrant, or anything that a union of the state gave to each one of you guys? Drop it in the comments. What bond do you have from a state? What certificate do you have from a state that is registered with the public entity? Drop it in the comments.
This is exactly what they're trying to do. And when I talked to them on the phone, they confirmed that they don't really want the car. They just want my signature. And not only that, but I pressed the guy to explain what's happening with their issue, right? So basically, he admitted that the issue is that they're trying to deposit the promissory note, and that they cannot collect the benefits of that note because I signed as the beneficiary. So he just confirmed basically what I already knew. And remember, I said they sent me a letter. So to stay in honor, I also sent them a letter. Now, in that letter, I revoked their power of attorney. I rescinded their security interest in the contract. And I outlined the violations in the contract as well. So they'll be receiving that tomorrow. Let's see what happens. Yes, this is exactly what they're trying to do.
Who runs the town. That's when you go get federal protection.
So he
You're gonna
did.
have to take that higher. You're gonna have to go to your next biggest city and file a straight federal suit against that judge, right? Because at the end of the day, if he's the highest in that city, you gotta hold him to his oath. And the reason why he's doing what he's doing is because he knows there's nobody above him.
No consequence. There's nobody above him.
And nobody is challenging him like he is. He's probably one of the first, or maybe he's one of the rare ones that actually challenge him. And that because the ones that probably challenged him before didn't take it to the next step.
And he's trying to make an example out of him.
Exactly. Because the thing is, you gotta, and then you file everything you can. Hey, this judge, you gotta file things against the judge. You have to file motions for him to recuse himself for what reasons you feel, whether it's he's practicing law from the bench, which is a really good one. The minute that right there, automatically, there's also conflict of interest.
Because he told the prosecutor in the case, he's like, hey, don't you want to object to that? And I was like, this cannot be real. But he tape recorded he went ahead and recorded, his whatever the case may be. And then he told the prosecutor didn't object or anything like that. And he told the prosecutor, hey, don't you want to object? And then my friend, hopefully he comes up or he's actually listening to this. He's like, no. He's like, yeah, I object. But I'm like, how can you do that? Like, you're practicing law from the bench. And I'm not a legal person like that, but right is right and wrong is wrong. You know certain things when you hear.
He's trying to help his friend. He's trying to help his friend in the field. It's just like when you out here with your buddy and your girl then busted you up on some shit and you got your buddy over here lying for you and you look at him a certain way like, didn't we go over here yesterday? That's the same shit they be doing. I've seen them do it to me in the same, in the same shit in the court. But to go back on what Chris was saying, and I'll try to be quick. This is why I disqualify the judge, because everything that Chris just said, I handle right at the beginning. I don't even let him go into all the extra stuff because the court case was initiated without due process every time, all the time, which means no due process. There can never be no jurisdiction. So I'm getting them for due process right from the rip, and I'm challenging jurisdiction, and all orders are void that perhaps may be given on the case right from the get-go. So therefore, we don't get off of it.
See it. He said he's challenging due process from the beginning, and he's challenging jurisdiction from the beginning. So even before he goes in there, he's like due process.
I don't even go in there.
You're not allowing me. You're not doing process, or whatever the case may be. You're just trying to hit me with this. So that's why he's challenging, putting it on the record beforehand.
Yeah, because you can't do nothing in a case without jurisdiction. Sorry, brother. Go ahead, brother. I'm sorry.
You good. I'm just gonna say I don't agree with anybody, and I don't agree with anybody going in there. I don't. But you have to send something in place if you're not going. You can't. And people told me that a long time ago. I was like, all right, cool. And then I stayed home and I got a warrant. But so what I'm saying to everybody who's listening, I do this shit from the couch. I don't go in there and participate in the buffoonery. I stay home. I send my paperwork. I disqualify the judge. Let them know that the initiation of the case, not the case itself. We don't go and argue the facts. We all know we owe, or we signed the agreement, whatever. I don't even get into all that BS. Yep. The fact is, you open an account in my name without authority. That's the due process right there. Every time, all the time. So. Right. That's what they're doing, and they're tax evading. So if you open a case with my name without authority, that's identity theft, right? So I got everything that you guys are going through your cases throughout the case periodically and calling out the violations. I got them all right up the beginning. You see what I mean? That's why they laugh at us when we go in there and challenge jurisdiction and I mean sometimes you can get away with some of these motions and stuff, but I don't even play motion games. I don't play none of that stuff. You open an account in my name, I'm gonna get you.
We have to have people to build up to that. That's why we actually have these type of
I'm trying to keep people from going. I'm trying to keep people from even going in there and what it takes to go in there. You can challenge, and it's the same process. So for the attorney and for the judge, yeah, I disqualified both of them before. So they both have to get permission from the secretary, and which is the Treasury, to even initiate the case, because the judge is initiating the case in the name of the estate. That's one. And then the attorney is trying to come in as heir under the estate. That's two. And they both got to get permission from the secretary. And since they don't, they're both tax evading or tax avoidance or whatever you want to call it, or attempting to. So, but if you don't say nothing, obviously, then the IRS ain't gonna know no better. So 26 USC 6903A and 26 USC 2032 AE11 for the attorney.
People who didn't, somebody put it in the chat form, so they can just write it down.
Those are
the things that you all hear. If you don't know what they are, just take a note of them and just go back and read it for yourself. You can't take every single thing people say for face value. In order for you to actually learn it and actually know it, you have to start somewhere. Don't be ashamed if you don't know the things. You have to learn it and you have to put it in your terms and say it over and over and over again until you know it the way that you know it, and you're able to express it in our.
Hey, you said 26 USC what, brother?
26. Okay, let me slow down. For the attorney, all the time, every time. 26 USC 2032 AE11. It's hard to find down in there throughout. It's a big chapter. It's a big sub-chapter, whatever you want to call it. It's kind of hard to find, but it's in there. The attorney's trying to come in as heir under the estate. They got to put up a bond to get maintain the tax liability. So they ain't doing that. Therefore, that's a violation. On the judge is 26 USC 6903A, right? He's got to give notice to the secretary. They both got to give notice to the secretary, and they ain't doing it. Therefore, that's due process. Therefore, I kick every case.
Facts.
I kick every case down with those two right there. I usually just stay on the judge, but if I want to go ham, I'll go in on the attorney too.
Big Real, what's the code you were telling us about yesterday or the day before yesterday about? I'll just put it in my terminology because I still don't know the code yet. The one where the lawyer is acting as a lawyer and they come in there on behalf of a company or something like that, and they don't have the rights to. What's the code now?
That's Texas. Somebody's got some bad feedback.
Oh my God.
Texas Rule 12, right? It's attorney no authority, and that is crucial. It's on my page. We got victories under that. It is a master bomb. So there's that. Okay, that you look up your state equivalents. Also, and I heard you talking earlier about jurisdiction in general. They have none. We're private. They don't. You guys listen.
Facts.
My state statute says to be in the state, you have to be on property. I mean, I'm summing this up. You got to be on property that's owned by or ceded to the United States. Okay, well, where's that? That's not in the street. That's not at your house. My house ain't never been ceded to or owned by United States. That's how I beat property tax. Simple shit. So what I'm saying is they're not even supposed to talk to us unless we're on their property. We're not in their jurisdiction. What's their property? Churches, schools. Churches. Sorry, museums, schools. You see the federal zones district. You know what it is. Their buildings, city buildings, county buildings, parks, military bases, dockyards. It's in the Constitution for the most part of what's been owned by or ceded to the United States.
So somebody said the post.
So if you ain't on
post office, they have no jurisdiction.
Yeah, okay.
Post office.
We'll rock. But I'm just saying, in any of those, if you ain't on any of those places, you can't even receive service or summons or this, that, and the third. So you could essentially beat them with service because you ain't in the state per statute. right? Per their own statute.
Can I speak on this real
I
quick?
thought
That's what I was gonna say. Hey, John, because I know John just put some stuff in there. Hey, guys, please just welcome, and like I said, follow everybody that's on the panel, and everyone else who's in the live. John, Stefan, can you please grace us with your knowledge as well?
Yeah, go ahead, guys.
And I want to touch on what the brother was saying. So the brother is right. This is what makes it a little difficult because everything he's saying is actually right. The problem is that no one still knows the difference or the full ramifications of jurisdiction. You see what I'm saying? And all these municipal courts that's contracting with you. Now, let's to make it simple and speak in layman's terms, everything that you're utilizing through the concepts of this commercial system, and if you don't establish a claim, whether it's on your property or your assets, then you're in the ramifications or the jurisdiction of the United States District of Columbia by way of the Buck Act, you know what I'm saying? Also by way of using their property, their codes, and all those other things as well. But the interesting part about this is that because you've been given a government, an agency, a bank, all those multiple things at one must know how to set up office or utilize the office in the appropriate manner. That way they can actually start receiving the proper judgment from these courts. Like, y'all ever realize that when you walk inside these federal courts, these district courts in certain places, and people always go with the theory that you're not the name, and the courts ask you, well, who are you? And then no one ever looks at the rules of evidence or establishes anything dealing with the judge or the county clerks, giving any documentation to express your position of who you are as in running the office. Like, the courts are literally there for you to receive payment, even if you go in court, because you should already process your administrative process using the bill of equity, just addressing these companies because a debt or an obligation already been prepaid. Plus they don't have the authority to demand payment. Plus they asking for money in the form of not currency, because we already know the Constitution essentially only establishes gold and silver. Like, it's so many ramifications that we're not grasping, you know what I mean? They make it more simple. And then not only the tax game itself, but the taxes are plus because so many people running from taxes and not realizing that the reporting is your remedy, because using the IRS forms to report these companies and on the merits of them not doing the proper reporting for themselves, because they don't use IRS forms, they use their forms. Then they report to the IRS to state that you never did the proper reporting. You see what I'm saying? So it's like just using these things accordingly how the system's supposed to go, and then having a more understanding about these things. And I promise you guys, it won't be as complicated as, as we think it is. We just got to get more into it. But I love the topic. I love everyone. It was wonderful. I'm going to have to go because I'm in the process of meeting the client, but I'm going to stick in a little bit to see if I can keep dropping more gems and answering these questions as I can. Thank you so much, Ms. T.
Thank you so much. We appreciate you, guys, and that's what we've been doing. I mean, we did this unknowingly. Like, we all didn't get together and say, "Oh, we're going to do this every other day, and we're going to do this." Like, literally, I just came up, and I've been on for like 4 days straight. I'll come on live around 9-10 o'clock in the morning, and all these lovely people will actually jump in. They'll go ahead and go on live. We'll all jump in. You see that there's no bumping heads. If we have a disagreement, we agree to disagree. There's no talking over one another, and every single last one of us knows how to articulate what we're articulating. Like Homestead Nation says, there's a lot of entertainers but not enough educators. We're not gurus by any means necessary. We're becoming subject matter experts. We're going through a journey, and we're trying to bring everyone along with us so that you all can become subject matter experts as well. And we're doing the journey thing because of the simple fact we want to actually show people, like people are always asking, show and prove, show and prove. If I'm showing you my journey, I'm dropping in and I'm giving you gems or whatever the case may be, and I'm not always talking about money. I'm not every single time something happens, I'm saying, "Oh, I got a class and it's $1,000," or "Oh, I'm not going to talk to you." It's how you present yourself. It's how you talk to people. It's not what you do, it's how you do it and how you actually speak to people. That's why I said you got to get around a lot of like-minded people. And if there's some people who actually don't know how to talk to people, maybe once they get around us, the people who are actually trying to make a difference, who are actually trying to bring everyone home or whatever the case may be, it'll probably rub off on them. That's why I'm never going to count Caleb and Tamika out or whatever, because I think that they have a lot of great knowledge. It's more so of how the presentment of it is, right? So I'll let somebody else go ahead and take the floor. I think I said what I had to say. I just want everybody to get along.
Hey, can I chime in on on Tamika and what's the name?
Hold on one second, McReal. John is going to step off, but he said he want to say something real quick.
Okay, my bad, John.
So, my apologies. I want to address something too, because here's the argument that a lot of y'all are not addressing. The issue is that a lot of people is coming at the debt and addressing the debt as an actual argument. Now, a debt means obligation based on performance or the transaction, okay? Your argument, and you don't use the word argument, what I'm saying, your argument or your stance will never be on the debt, okay? Because the debt is based on the obligation on your performance. When you're bringing up the merits of an instrument and how you're supposed to address it before you go to court, or when you're dealing with a debt collector or a company, no matter who it is, you always address the merits of the instrument, and knowing that the validity falls in the realms of them having the original, but they don't have the original. You see what I'm saying? Mm-hmm. So you always start in the beginning of doing a debt validation amongst that instrument. If they give you a copy and they still trying to make you perform based on that copy, don't accept that forgery. Utilize the concepts of making them prove. You see what I'm saying? That way you pushes them in the corner. If they don't follow suit, then this is when you kick in with the administrative process, the paperwork and the procedures you're supposed to do correctly. That way when you give them a notice and give them a heads up, basically establishing the bill of equity, saying that this debt has already been fulfilled according to which way y'all go to, whether using Title 18 USC 8 or the obligation of being fraudulent or other concepts, you know what I'm saying, of having a claim and recoupment or any other defense, right? Because it's the instrument. No one's presenting the claim as hold in due course. Because if you don't use the position as hold in due course, especially when these documents are matured, once they are matured and reach their maturity, your hold in due course position you lose your position, I'm sorry. So a lot of things needs to be taken in retrospect and actually move forward. It's the instrument and based on obligation. Now, when you guys get into court or before you get to court, that's going to be the same thing based on performance, based on the property, never the debt, never about the instrument. Essentially, what did you do and what they didn't do? And then you would use that and push them with all the evidence that you gathered. So it's very, very simple, as in like following the paperwork. That's why it's something that shouldn't be rushed. Everyone should take their time, get with other people who are familiar with the administrative process, get with all these other people who actually experience in courts or actually had conversed with these different companies and have some track records or some testimonies and things like that. And y'all get together and start building the paperwork. Because if I don't know if y'all catching in on what's going on, shit is moving 10 times as faster. Y'all still chasing money and chasing all these illusions when that's not the issue. That is not the issue. Stop chasing imaginary things and start actually chasing reality. And it's all based on possessions, property. You see what I mean? And you got to get people out your pockets. It's as simple as that. But I love y'all. Appreciate me jumping on. I just catch y'all next time.
Thank you so much again for that. Go ahead. I think it's Dirty Joe McReal.
No, he said administrative process, and I agree. The administrative process, if you use it right, is deadly. It's deadly. I mean, if you heard me before, I set them up on administrative process. I know that's what I wasn't talking about before, but since he brought it up, but I used the administrative process to set them up. And I know that, and I asked, and if you see my talks, I asked the servicer or the collector for something I already know the answer to, for something he don't have, which is the credit, which is the initial application, the 12 USC 412 application. That's the original instrument that everything is created from. So when you ask the debt collector for that and they can't produce it, you know, they're in trouble. I mean, and I set it up in a fashion to where that their response can be considered conspiracy. Because if you send me something other than the original instrument that I asked for, well, then you're pretending like you're somebody you're not, and we both know they ain't the creditor. Shit.
So we have to learn how to not mix everything together. I'll say it like that, because if you're going in there and you're talking about debt, then you're actually validating the debt. You have to stand on what you know about. I don't know if I'm saying it in the proper way, but someone correct me if I'm wrong. The instrument is what it is. So if you present this instrument to say at such company or whatever the case may be, and they deny that instrument, that means the debt is discharged, right? And so if the debt is discharged, what do you have to do? You have to report it to somebody that they didn't accept that instrument, right? And so
you just keep it as you put that in your default, and when you put that I'm sorry, I didn't mean to cut you off. I didn't know if he was going right there. If they deny tender, then I just say it like this: it's UCC. Once tender is made and tender is denied, then there's discharge. But I say a debt refused is a debt paid, which everybody knows that.
Right.
So it's the same thing. If you're entitled to enforce it, which if you're contacting me, you're assuming that role, and then I make tender. I do all those three things that I just said in one stroke. I offer the tender, because I know they don't have the original instrument, so therefore I ask for tender, and then so I can make it payable. So now I just got them. They can't send it. So now you just denied payment, and then you're restraining my trade.
And then, guys,
hey, black know what I'm talking about. So now you're just restraining my trade, and if you respond incorrectly or sending me part of an application from someone else, now it's conspiracy. So I got you on three things all at the same time with one question.
So if they deny it, so like I said, if they deny it, that means like they're denying your form of payment. It's an instrument. That's all it is, because we all know that there's no lawful money. So therefore, this instrument that you're presenting to them, and sometimes they'll go ahead and keep your instrument, because then they can always come back and say, hey, I kept it. I didn't send it back to them, or whatever the case may be. I didn't deny him. I just didn't respond back to him or whatever. But that's what they mean by, perfect your administrative process. I'm not by any means saying that I know for a fact what this administrative process is supposed to be. There's going to be somebody who's going to come on here one day who's going to explain to you what the administrative process is. The way that I see what an administrative process is the same process that they do to you in order to say that you're in default or something. You just switch it around and you do the same thing, and you send that information back to them. You're able to do it. I'll say this, and this is my thing. This is my thing right here. Our signatures, we are made in his image. We are God. They bamboozled us for so long, or whatever the case may be. We sign our names to an application. They do what they're supposed to. And therefore, we're not giving them instructions on what they're actually supposed to do with it. We were supposed to do the application. We know what we're supposed to do with it. Hey, give me my securities. I'm supposed to be getting the check back every single month. You don't get any of this money. They switched roles with us. They switched the roles with us, and they just kept going back and doing it. So that's how it's actually fraud. But we need to learn how to articulate it. And so that's why we have forms like this, or whatever the case may be. And it's not all about getting the bag. Like literally, if you're getting into this because you're trying to get some money or whatever the case may be, and not actually learn the process and create generational wealth. I never say I want to be rich. I always say I want to be wealthy, because of the simple fact I want to be wealthy in knowledge. I want to create wealth for my family and the people who are around me. So if you're getting into it, the bag is going to come. But if you're getting into it for that, like, it's not going to come fast enough, because you need these things right now. Like, you need these things right now. Never give something to somebody that you need right back. So that's why I'm saying that. Get into it because of the simple fact you want to learn it, you want to pass it down, you want to educate people, or whatever the case may be, and then that's how you truly win.
Let me explain a simple administrative process. This is kind of how I beat up on let's say student loan, right? Everybody usually has student loan. I got a check back from my student loan. That's what's funny. I got a check back for $5. I never cashed it. It's evidence, right? So check it out. Administrative process. So the servicer is coming after you for the government loan. The government can't do it themselves because that violates the FDCPA. Right? Can't use the United States or the state in the collection of any debt. Right? 1692E3, or E in general, sorry. 15 USC 1692E. All right, so we asked the servicer for something that only the creditor would have, which is the application, right? I mean, you don't ask them like that. I ask them for the instrument on the underlying obligation so I can make it payable. Okay, what did I just do? Now I just said, send me something so I can make it payable, and we can kill it. We can dead this to the situation. But since they don't have it, they're denying payment. I just put them in a box. So if they don't have it, they refuse tender, and then restraint of trade. That's 15 USC 1. That's a $100 million fine. And then based on their answer or the response, that it could be considered conspiracy. That's what I said earlier, right? Okay, so the first one is notice of liability. And then it's just going to be simple, like, hey, send me the instrument on the line application so I can make it payable. If you feel as though I owe you something, I'll make a spew. It's a nonchalant notice. It really don't mean shit, and they usually ignore it. Then on the second one, I give them, like I said, I give them 5 days upon receipt of this notice. That's 8 days. Okay, once they don't respond, I'll send them a notice. Tender, hey, I try to, I try to tender payment. If you refuse, it could be considered restraint of trade pursuant to 15 USC 1, right? Be careful how you answer, or you might be conspiracy at 15 USC 2. Now they're scrambling in a fashion to try to answer me, and I can tell how fast they respond, right? So now they got 5, and I give them 5 days upon receipt of this notice. And think you're stupid and send you something that don't matter, or part of something that might consider. Yes. So now it's a default. It's a default after that. And in the tacit agreement to the following, you agree that you refuse payment, and you also you're based on your conduct, you also restrain my trade. So you tacit agreed to the you 15 USC 1, and then since you sent me part of the application, knowing you don't have the full application, it's 15 USC 2 conspiracy, and now you agree to you owe me 3 times the amount of the full debt. Blah blah blah. You just kind of throw it in there how you want to. It's more like new terms and conditions, right? If you will, tacit agreement is more like new terms and conditions. You agree to all these things upon default, and I can render my judgment, in a court of competent jurisdiction. And now it's over. So now you can take the default and attach it to your if you want to do your credit cleanup, and you can send it right over there to the credit bureaus and get the student loan removed from your credit report, right? And then if these guys if you want to make a court issue, you can. You already got the default. You can run it. You can run it like that, or you can wait for them to do it and then kill the whole case with the default, right? Put your default on as evidence in response in a respondents to their petition, and it's over. And ask for summary judgment or a declaratory judgment, whatever whatever the case may be. You don't even have to go in there.
And that's what a lot of people have been saying that have been on the panel. Because remember, there really no courts, but the court that you go to, it's nothing but a bank. It's all about bonds. It's all about getting the money. So by the time you get to court, you've done your administrative process. You're just going to get paid. That's the only thing that you're going to do. You're just going to get paid. And if you just listen to the things that are actually going on, and you have to know your place, and you actually have to know who you are. For so long, we've thought that we were actually going to get credit from them and things like that. But in all actuality and all truth, they're borrowing from us, right? Because at the end of the day, our signature is the one that lent them the money. But we didn't know our place in the beginning. And so now we're trying to keep people have people to wake up so that we won't have to go back and do this remittance thing and fix what it is. Because at the end of the day, you'll have to go back and you'll have to correct what you did in the beginning, which is the application or the contract and things like that. So I will say this to you: just because you get an application just because they give you a contract when you're going to do your mortgage, or just because they give you a contract when you're going to get these cars and things like that, now that you know, and you've heard it for 5 long days now, you've heard it in 100K seminars, you've heard Chris say it, you've heard me say it, you've heard every single person on the panel say it. When you get that contract, know your role, know who you are. You're given direction. You're the head and not the tail. So you're going to get that security agreement, right? You're going to cross out that security agreement, giving them full access and making them think that they're going to be you, and they're going to get those dividends back from the security, right? They're not going to do that because you're going to give them instruction. You're going to tell them what to do. They're going to take that money they're going to take that signature and that application to whoever they need to take it to. They're going to get the money. They have the instructions already, and then they're going to come back to do what they have to do. But I'm going to give you all a quick story real quick, and I'm going to hand it over to somebody else. Now, I've done my administrative process on the Jeep that I had, right? I sent all my letters. The dealership, they'll ignore my letters and things like that. The bank, they'll ignore, the lender will ignore my letters until I got into the nitty gritty of it, right? So I got a telephone call back yesterday, myself and Elena, because I didn't want them to keep talking. So I called Elena and put her on the phone so she can bear witness to what was going on. The guy called me. His name was, we'll call him Jim. Jim called me. He's like, hey, Tanika, and he's hostile when he calls me on the phone, right? He's like, Tanika, what is it? What do you want? You keep sending us stuff certified and registered mail. What is going on? I'm like, hey, how you doing? What's going on? Can we calm down for a second so we can have a honorable conversation? And he's trying to tell me, well, you don't know what you're talking about. And this, I never told him what I was talking about. I stopped him because I just wanted to listen to what he had to say because he was so hostile when he was on the phone. And I'm thinking in my head what the questions that I'm about to ask him, right? So he's going on and on and on and on. He's like, because you don't even know what you're talking about. What are you talking about? This Alliance? What are you talking about? The security agreements and this and that. You're trying to use big words in these letters that you're sending us. And when I opened it up, as soon as he said, when I opened it up, I'm going to tell you this right here. As soon as he said, when I opened it up and I sent this restrictive registered mail, meaning the only person that can open this piece of registered private mail is the person that it's addressed to. So as soon as he said that, I said, oh, you opened it up? You opened it up. He said, yeah, I opened it up and I showed my general manager because it says general manager on here. I said, no, I'm sitting here looking at my copy of it. And also I'm looking at my phone book and I'm seeing who I sent it to. I'm reading off the numbers to him. He was like, that doesn't matter who you sent it to. Like I said, you're using these smart words and you're sounding dumb on the phone. I let him say what he had to say because he was in an uproar. I didn't have to be in an uproar, so I'm just listening to what he has to say. You all know that I'm dramatic, so you might see me do this and you might see me do that, right? So when he said that, I said, well, no. I said the mail was addressed to your CFO, your indentured trustee, and your CEO. Your name was nowhere on there, and it was a restrictive registered mail that was sent to him. I said, so since you said that you opened it up, I said, do you know that's tampering with federal, you're tampering with federal mail? That's a federal offense. You open someone else's mail, someone's registered mail. He was like, no, you sent it to the general manager. And so I let him talk and he's asking me all of this. He was like, so what do you mean you put in a line with this? And so you never want to tell them like, oh, you did something wrong. I'm trying to remain in honor. So my whole step of the way, even when I sent them this, the information that I'm sending them, I never said that you all are at fault. You did this, you did that. This is what I said to them. I said, hey, when I originally did my application and I originally did my contract, I said I did not agree with all of the terms and conditions. So therefore, I did some conditional acceptances. And I went ahead and put those things as an allonge. He's like, well, what is an allonge? You keep saying this word allonge. You keep trying to say smart. I said, well, an allonge is, and this is what an allonge does. You know how when you don't have enough paper to write on and you have to put it on something else, and I just attached that information to that, and I went ahead and I did the bookkeeping on there as well. I did that on the allonge, right? And then he was like, well, I don't understand it, and you don't understand it because I'm the finance guy and I signed off on this. And Becky, her name was Becky. It wasn't Becky, but I'm going to call her Becky for today. Becky said that Becky didn't understand that application and the security agreements and things like that. I said, well, if Becky didn't understand that, why would you have Becky out there representing the company and filling this out with me and me giving her direction? And, somehow, some way it may have been. the sale. Well, she thought she was taking the sale, but Antoine, the other person over there, they were arguing about who was going to actually get credit from the commission from this particular sale. And you went ahead and granted it to her. So I know who you are, and I know you were in that office, and you didn't sign. She signed because I have the contract right here. You didn't sign off on it. Well, that doesn't matter because she just didn't understand. I said, well, her not understanding should not be an issue because she's representing your company. That doesn't matter, and you're ignorant. I said, well, you're the person who didn't know what an allonge was. And he's like, well, people don't understand everything. I said, right. So every single thing that I said, I'm just telling him, I said, every single thing that I said, since you keep saying that you don't understand, I said, write these things down and just send it to the proper person who I addressed it to. He's like, well, they told me to take care of it. I said, they wouldn't have told you to take care of it because if they would have read my letter, every single thing that I have in there, they would have known that I said, he's called CFO for a reason, Chief Financial Officer. So the things that you might not know, I'm guaranteeing to you that he will know. I said, you know how that works? When you're in third grade, you might not know what a fifth grader is doing. Because you're in third grade, you don't know what the fifth grade work is like. And I compared it to that with the CFO with him. He was livid. And I'm not telling you all the story. Elena was on the phone with me. So by the time we get off the phone, he's like, you know what? I'm not about to do this anymore. And I said, well, can we just take it back to you opening his mail? Are you going to give him his mail, that piece of registered mail where the number is this, and that, and it was restricted to this person opening it? And you know you committed mail fraud by opening mail that was addressed to him. I'm not going to talk to you anymore because you're not a smart person and this, and that. And I said, well, you're the person who didn't know what a allonge was. I said, have him to call me though. You have a good rest of your day, sir.
That's how you get them.
Livid. He was.
That's how you get them right there.
I remained calm and I said throughout the conversation, I said, I just want to have an honorable conversation with you. I'm going to remain in honor this entire time. He's like, you keep sending us stuff here. You keep sending it to us. I said, well, I'm sending it because you're not responding it. You're not responding to it. And I'm trying to give you an honorable way to do whatever it is that you're doing. I said, I just want to get you the information. And because you don't understand it does not mean that CFO doesn't understand it. So basically what they were doing is every single time that I sent them something, they held it to their chest because they know. I never said, oh, well, you did this or you didn't do that. I said, well, maybe since I attached the allonge to the actual application or whatever the case may be, maybe it slipped off because she had it paper clipped on there. He's like, so what do you want? What do you want? I said, well, it's not about what I want. I said, what's right is right and what's wrong is wrong. And maybe you just need to give this information to the CFO so that he can handle the issue at hand. And I left it like that. I did. I went on the Attorney General's website. This is back in Illinois. I went on the Attorney General's website. I went on the Secretary of State's website. I did a 3949A and I also did a 211 at the advice of the great people here on the panel. I did all of that, and I think I'm doing the administrative process along the way. So you all are going through my information. You all are going through my journey with me. Elena was on the phone with me when all this was happening. Gary was pissed off at the end of this conversation because I just kept saying, I'm just trying to remain in honor, Gary. And I was like, Gary, I said, I gave you 3 words. Those 3 words, you email it to your CFO and your CFO is going to call me. Nobody's going to call you back because you're ignorant. I said, Gary, I'm not ignorant and I'm not dumb. I said, I have a master's in criminal psychology, Gary. I said, no, you're the person who didn't understand, but I'm trying to explain it to you. He was like, well, explain it to me. What do you want? It's not about what I want, Gary. It's about what I need for you to do. And you can't handle the issue at hand, so send it to someone who can. I remained in honor the entire time. Gary admitted to me on the phone while a witness was on there that he opened a piece of registered mail that was not addressed to him, right? That's mail fraud, mail tampering. And I know so, and I can bring charges against him. And you know why I can bring charges against him? Because I have my firm book. I have, when I sent that stuff out, certified mail, when I sent the information out, registered mail, and I canceled everything out as to how it was supposed to do. So what does that make me? It makes me my own postmaster, right? I'm the postmaster now. You don't play with the postmaster. You do not play with the postmaster. So I said all of that to say, guys, come and listen to some of the things that people have to say. Take it. Did I record the call? No, I didn't record the call, right? But I did have a witness on the line, and I also have the timestamp and date that he actually called me, because he did actually call me. And also what I'm going to do is I'm going to write an affidavit out about what actually happened. I know a lot of people don't like to do affidavits. And when I do my affidavit about what happened, Elena's going to be one of my witnesses, right? She's going to be a witness. But then what else am I going to do? I'm going to take that affidavit with my witness signature on there, and I'm going to take it to 3 different notaries. And so the notaries take the oath of office, right?
I would get her to make her own affidavit about what she heard on her versus her through her eyes or ears, and you make your own as well. And then you have her get her shit notarized, and then you make your affidavit mentioning her within as being a witness, and then you just get yours notarized, and then you put them both together.
Yeah. That's what they're gonna do. And I mean, honestly, it's not about being upset about things anymore. It's like once you start gathering these things and once you start listening to it over and over and over again and not understanding it how someone else actually understands it, but understand it and you make that story and you put it in your head how you want to. And now I'm actually starting to really understand. It all goes back to ledgering. It all goes back to these floating rate notes and things like that. And it's going back to you actually staying in honor, not going and being argumentative. Yeah, you can stake your claim. You can make your claim. You can give the facts. You can go ahead and do your administrative process. You can do every single thing that you need to do by staying in honor and just presenting the facts. Like, you don't have to do all of the other stuff. Just present the facts about what you know. Like literally what you know. There were only 3 people there for that conversation. Myself, Elena, and Gary. And if Gary had somebody in the office with him, right? Anybody else that's outside of that, any attorneys or anything, is secondhand knowledge. I was there. Elena was there. Gary was there. And guess what? Our 2 admissions to what happened is going to trump his, right? So just listen to people and just gather it and then just learn it the way you want to. And I was going to say about things always go back to the Bible, right? And so I'm thinking, like, when I was younger and I used to be in church and the minister used to always read what he had to say, but then he used to make a story about it to tell it how it would be told for people to understand it. And so that's what you have to do when it comes to this. You learn these codes and these statutes and things like that, and you just have to remember it in the way that you want to say it, because it's only going to come out the way that you want to say it, how you understand it. And I'll let somebody else talk.
Yeah, you gotta basically become your own private investigator with this shit. You gotta make sure that you got all your ducks in a row before you even. How I think about it is, you gotta have your last T across and your last I dotted before you do any claims in anybody's court, so you can know that you have all your shit fully done and don't have to worry about no rebuttal. By the time you go into, if you have to go into these courts, by the time you already won it before you even send your paperwork off.
And me and Carvana, guys, as I'm looking into my arbitration clause and things like that, Carvana and all these other places, they think they're extremely slick, right? And I was telling Dirty Joe this too. When they try to go ahead and go to court and they do all these other things, if you really, now that you know, you sit back and you actually look at that contract and they try to repossess your car and they try to do all of these things or whatever the case may be, the contract is null and void because they voided out when they did and they didn't follow a due process. They went ahead and repossessed your car, right? They went ahead and sold your car. Like, they're literally doing these things. And also, they didn't try to do an administrative process before they did all of these things, right? And so they had it in the contract, and me and Dirty Joe were looking at it where it says
They do administrative process. They do administrative process. They do a notice one, and they do a second notice, and maybe it might even say opportunity to cure. I know at least on my credit card it did. And then they do a final note. I mean, those are their administrative process. The final notice, the default, those are their simple administrative process. And to go back on the agreement, like you said, we signed in blank. So when you say to cross these things out, you don't have to cross these things out. The endorsement dictates the contract, the terms, whether it's for collection or for deposit. That's all it is. All the other stuff is hogwash. But if you sign in blank, just sign your name like we normally do. Now they can pick it up, and you gotta abide by the terms. You agreed to upon default to let them come snatch the car up without a warrant to circumvent the Fourth Amendment, right? You helped them break the law.
I'm sorry. That's why I think
So I mean,
that like you can't just jump into it. Like, this is not like a fast process. And so when you say restrictive endorsements and things like that, I don't know completely about all
I was just about that,
to do these endorsements. So my way of saying that I'm taking you through my journey, I'm pretty sure that I'm going to learn the way of how to actually close it out. Now I know that what I did with the promissory note when I did my mortgage, when it was just my signature on there, and they did not what do you call that, what's that stamp that notarize it, it left it blanked. And that means that they can go do what they want to do with it because there were no other signatures on there, and we didn't get it closed out by notarizing it or whatever the case may be. Now I know now I know it's not right. And so now what I can do is I can go back and tell people about my journey to say, hey, if you're going to that closing table, if you're doing this, or if you go, this is what it is. You have to acknowledge these things. You can accept your deed. Like, you can tell them, no, where's my check at? You said that this is a loan, and y'all don't make me even go on the mortgage thing for a loan.
She must have got a phone call.
Here, for a loan that I have received, I promise to pay you. You didn't receive a loan because you didn't get a check right there at that closing table. That's not a loan. That's not a promissory note. That's a security because of the term of it. It's 30 years or whatever. But once you actually really get into it, you can get you a dictionary, get you a Black Laws dictionary, get you something and look at the terminology and just look at these contracts, and you'll be like, this ain't right. But it's going to take time. It won't just come overnight. You have to have a village of people. You actually have to have a village of people behind you to say, well, hey, look at this, do it this way, do it that way, because of the simple fact you don't know everything. You have to be open to actually learning from others. Who's at the top right there? Non-need. I'm sorry. What's your name?
I think he had a question.
Can you go ahead? I'm sorry.
No problem at all. I love listening to y'all. But a situation also happened with me yesterday. I bought a car, and I'm totally new to all this. My ignorance is through the roof on how this stuff goes. That's why I started following you guys a couple weeks ago, trying to figure all this out. But I bought a car yesterday, financed it, 2020 Nissan Maxima, and I got dropped off by a Lyft to this used car dealer to pick it up. I was putting $1,100 down, and the guy said he can get me approved because my credit is shot. I'm working on that. I wanted this car so I could build my credit. But I was also pressed for time because my son had got sick at daycare, so I was in a rush to try to get all this done so I can leave because, again, I had no ride. I got dropped off by a Lyft. So they went through all the paperwork and everything else. I originally came up there to pick up a Dodge Charger, not a Nissan Maxima. They said they couldn't get me approved for the Charger, so the Maxima was the next best thing. And I was like, well, how many miles? Is it good? They was like, yeah, everything's cool. It's brand new. Only got 31,000 miles on it. Like, you should be good. I'm like, okay,
cool.
Can
I stop you right there? Let me just stop you.
Yes.
You literally just did this yesterday. You literally just did this yesterday. And you literally just did this yesterday, so you can go right back today. Literally go right back today, and you can fix that. I'll let Dirty Joe or Chris go ahead, and I don't even want you to go even further in the story because this is an easy fix. And you don't say your credit is shot because your credit is not shot. Your credit isn't shot. Remember, we're the head, not the tail. Your credit is not shot. You have an inheritance, and I'm just gonna take it back to the Bible, right? Listen, we're God's heirs. We're made in His image, so your credit is not shot. God's credit isn't. We have to learn to stop speaking these things on ourselves, because when we place it out there in the atmosphere, I'm the type of person who believes if you say it, you're going to will it. If you say those things, you're going to will it. So you have to say, hey, I did that process right there. Now I got a team of people right here who collectively may be subject matter experts on something, and I can correct it. I can correct this. This is something that's correctable. It's literally, you can see, it's simple. So, Chris, Dirty Joe.
You want to do this? What you want to do?
Go ahead. I'm like doing something real quick.
I'm sorry. Go ahead, Dirty Joe.
Okay, so First things first, I would say you do have a right to rescind the contract, get your money back, and return the vehicle if that's what you so decide to do. The second thing, anytime that you're looking at your contract, especially when you're sitting up here looking at the retail installment contract, you can look on there and see who has security interest. And if it does not say you, the actual buyer, you might want to go in and tell them you want to amend these things. So you have two options when it comes to your contract. You can rescind it, which is a full cancellation of everything, or you can amend the contract so that you can reap the benefits off of that contract. So go back and look at your retail installment contract and see who has security interest. That'll show who has the power. If they take you out of jurisdiction and put you back in, then you're supposed to initially have the power. You need to get that changed in writing.
So you don't want to rescind the contract. You can rescind the entire contract, but you don't want to rescind the contract in this particular aspect because you don't have to accept that car. If you had your mind set on getting this Charger, you didn't have to take that Nissan. What it is they went ahead and shuffled your application out to a lot of different people. That's exactly what they did. They shuffled that application in the highest bidder because, as I've learned from the group of people that I deal with now, every single last car on that lot is already paid for. They already went to the Federal Reserve. They already went to the Feds to go get the money for those. Those cars are paid for.
Wow. Yeah, and the insurance is supposed to be in your contract. Like,
let me add to that real quick.
Oh, go ahead, Chris.
The fact that that car is already paid for, right? First of all, the car that you actually applied for is already paid for. So basically what they did was they went and got, they pretty much processed your application for the cost of the Charger. And for them to make more money, they said, well, we didn't approve you for that, but we can get you in the car and give you a car that was lesser than the amount that they sold your promissory note for, right? So that they can keep a lot more of the money. Now, what you can do is you can say notice of subrogation on your original contract. Reason why, then they're going to have to give you that money back as well as let you keep the car.
So that's why I said you don't want to rescind it. You can go back and you can correct it. Subrogation, and so
amend it or subrogation.
So this is where your administrative process needs to be on game. You need to send that notice of subrogation. Now, if they deny that, now that's a lawsuit. Now you can get them for conspiracy to commit securities fraud. Then you can send them a notice of default and then put that in there, notice of default on security interest, all this stuff, right? And you can put into that letter letting them know that, hey, the ignorance, subrogation, exoneration. You can also say notice of default, send them the amount of money that they owe you off of that promissory note. And mind you, this don't got nothing to do with the car. This got something to do with the promissory note now. So you're telling them that you owe me the money from the deposit that I've given you, right? So now they're going to have to pay that back to you. And if they don't, then now you got a lawsuit, that's securities fraud, and eventually they'll give it to you. But you got to do your, I know that was a little quick. You got to do that administrative process and do those notices. And you got to at least do a notice 3 times. The power, I'm going to say, anybody who's listening to us, the power of 3. If you ever notice, everything is done in 3s when it comes to banking. You got to give them 3 notices. 3 notices is the number of witness. Even when you don't have a notary, what did they tell you to get? 3 witnesses. Right? So make sure you give them notice of 3 notices, so that when you have to take them to court, if they don't acquiesce to your demand, you have to take them to the court, then you have, that evidence. But you want to try the administrative private process first, which is doing a notice of subrogation, sending them a letter of what you want done with those securities that they got to give it to you. Now, there's a lot of laws behind that, so I can't give that to you right now, but I know they can. There's laws where you can put into your notices to let them know, hey, by this law, you're supposed to give this back because this is what this is. This is a security. You guys, I'm rescinding that security interest. I want that security interest back. You did not give me the vehicle that I paid for, all this stuff. There's a lot of things you can do in your own words, but just make sure that you are very specific in what it is you want. Otherwise, they're not going to take you seriously.
And why the guy says that he owns a car dealership and he's asking, is it a buy here, pay here place? Wise guy also said that they don't go to the Federal Reserve to actually get the money. Of course they don't, but whomever sponsored them, because every single car, Wise guy, correct us if we're wrong, every single car on that lot is already paid for. It's already paid for.
Every car on that lot is paid for, as well as your insurance. Because I learned that when I was working in claims. I
can't see his name because my glasses, guys. But case in point, Amelia is not on here. I don't think that she's on this particular live right here. But when I tell you, she just, like, her car, she doesn't have to do anything anymore because she went in there, she did what she was supposed to do, and when she signed her name, instead of putting subrogation or anything like that, I believe she signed her name, her syntax signature, and then she put beneficiary behind it. They accepted her paperwork, she left with the car, right? So they call her back, they're like, we're not trying to get the car back, but we need for you to come up in here and we need for you to redo this contract. She's like, well, no, I'm not coming back in there to redo the contract. We did what we needed to do. And you know why? Because they can no longer do anything with that promissory note. They can't do anything else with it because of the way that she signed. Now they're trying to get her to come back in there. They know they can't take the car back from her, but it's nothing else that they can do because she basically did a restrictive endorsement. There's nothing, literally nothing they can do but keep begging her to actually come back up in there.
She needs to go back and get her money. She needs to administrate the process for her money now.
He's doing
and then go about it like that there, because it's a wrap. They just need her to recontract. They want to recontract because they want the funds.
No,
and they can't get them the way she find it.
No, Shonda, it's not just for newer purchases. You can actually go back. Like we're talking about, like if you do it right in the beginning, you won't have to worry about the remittance coupons and doing all of this other stuff.
Right.
And the reason we're saying do it right in the beginning, guys, is because those security interests, the money that's coming back off of because they sold your promissory note. They sold it and turned it into a security, and they shuffled it out to a lot of different people, and they made their money back. They made the money back right then and there. And so what's happening is they're receiving the proceeds from the money that you should be getting back because you didn't do it correctly. If you did the contract correctly, the proceeds would be coming back to you every single month in a check instead of coming to you every single month in a bill. So they're double, triple dipping. And so that's why we say do it right in the beginning, and we don't have to do remittance coupons anymore. We ain't got
I'm gonna give you a prime example, Tanika. A prime example.
Don't get it twisted. You can always go back and fix it. You can always go back and go back into the transaction that you might have already did, like in your bills, your water, your phone, and that stuff like there. And they're gonna put up a fight. They're gonna put up a fight, but you can still put
Let me just give you a prime example of exactly what she's talking about. So in your retail installment contracts, it talks about how it'll say specifically you have security interest in this vehicle. It says it on your retail installment contract. They're not talking about you, the consumer. They're talking about the car dealership. And what you give them security interest in, imagine getting a check every time. So you get a check, oh, I got to go get an oil change. That's a check. Oh, I got to go get this part fixed. That's a check because they're getting interest off of every bit and part of it. Oh, let me cancel this warranty. That's a check. Oh, you got a refund back for that canceling out that warranty? That's a check. That's an extra check because you get interest off of all of that. You got to read it though.
Right, and if you can do
we're abandoning all that shit. So that's why they hence the 1099A. We ain't supposed to be filing that shit. They are because we left everything at the table.
We left everything at the table, and I was just about to say that. Because of the simple fact we're not reporting these things and they're reporting it the way that they want to report it, so they can be doing book entries that aren't proper, right? We know that they wouldn't do it, but we know that they are doing it, right? So that's what they're doing, and I always say it's about bookkeeping, right? So, and I'll just say I'll use my mortgage case in point. I went back and I fixed it, right? And so just like Homestead Nation just said, if they're doing this with cars and everyday bills that are coming in the mail, you absolutely can do it with the mortgage. So my process with my mortgage is because we have like a lot of new people who haven't been on here before. I went ahead and I did a process with the promissory note, and me, Elena Lee, we read that promissory note backwards and forwards, and we're just like, just in the first line, it's fraud, right? Because you said that you gave me a loan and I'm going to promise to pay you, but I didn't get a payment there at the check. So what I did is I just went ahead and closed the promissory note out. I took my promissory note and I added an allowance to it, right? I did the Stamp Duty Act and put the amount of the house, right? So what they told me is when I look at all my paperwork, it says my home was $500,000, right? So $500,000, it says this house costs us $500,000. Then the bank says, negative, we gave you $500,000, and that's all that's there, right? And then they had my signature on there, their signature's not on there. They did not get a notary. So therefore that's open. And what they do is they take that promissory note, which we all know a promissory note is only good for how long? 9 to 12 months. Anything after that is a security. So they took that security and they went and they shredded the original copy. They shredded the original copy. They destroyed the original copy of your promissory notes, right? And then they made 10 copies of it. Once they made those 10 copies, they sold every single last one of your copies, right? And then what's happening from that? Every single time that person makes money off of one of those 10 promissory notes that they sent out, the proceeds from the interest that comes back in, they get it. The mortgage company gets it. The person who did your bank loan, they are getting it. Remember, the bank cannot lend their own money. They can only do deposits, right? So if they're making money up off of that and they're banking on us not knowing these things. So they're making the money off of that. So what I did once I got the knowledge that I got from the community of people who I call friends now, they're not gurus, they're subject matter experts on the things that they know about it. So what I did is I took that promissory note. I did my ledgering. Hello? So they said the house is $500,000. They say they gave me $500,000. I closed it out and said that I gave them $500,000 back with that instrument that I used to pay them. Right? So I show you my books. You got to show me your books. So I called the closing attorney.
Make any bombo clock child support case go away. Check here. Title 4 Social Security. Part D, Section 458, check here. The amount they get paid is equal to the amount of the incentive payment pool, which starts at over $400 million a year, plus the state incentive payment share. The incentive payment share is equal to the incentive base amount divided by the incentive base amounts for all the states. The incentive base amount is the amount of money they collect from you in child support. The more money they get from your child support, the more money they get paid. This is some wicked people, bro. Check here. They get reimbursed 2 out of every $3 they spend keeping you in child support court. Bombo clots. Check here. The code of conduct for judges. A judge should not allow social, political, financial, or other relationships to influence judicial conduct. It's a conflict of interest. No state can hear it. Bombo clots. So you want me show how to make any bombo clot child support case go away? Check here.